Mr. Chairman and members of the board. I've lived in Savage for 5 years. I recently purchased my home about a year ago after renting it for 4 years. I'm proud to call Savage my home, and I'm concerned with the proposal being considered today. The Department of Planning and Zoning recommended approval of the SP-15-017 by stating the following: approval of the preliminary equivalent sketch plan in accordance with remaining subdivision review committee comments, alternative compliance approvals, final approval of the land swap, and subject to any conditions by the planning board. Currently, the alternative compliance review is on hold pending decision by the board on the equivalent sketch plan. Furthermore, the land swap has not been considered by the county council, and the timing suggests that it will not be considered until after a decision by this board. The criteria put forth by the board to evaluate the sketch plan hinge on the approval of the land swap. In consideration of such cases, I believe timing should be important. I'm not sure about quasi-judicial rules, but consider, for example, a law that has not yet taken effect. If a lawsuit is filed to change this law, the case would be dismissed until the law takes effect. By the same token, how is a petition based on an event that has not taken place being considered? Why is the land swap and that potential event being considered in this petition? I think the board should not be looking at things as they could be, but as they are right now. Similarly, the alternative compliance petition, which has not received a decision, paves the way for claims made to demonstrate meeting the criteria. Furthermore, the circular nature of the decision to withhold further action until the planning board review is complete on one hand, and then to give conditional review on the other, is troubling. To my knowledge, the parkland is currently not in possession of the developer, and even the DPZ review acknowledges that the State Department of Natural Resources will then formally review the swap and begin the federal review process. The current subdivision design is based upon anticipated approval of the land swap, quote unquote, which brings into question the claims of a technically complete plan. I think it's completely inappropriate that this plan is currently being considered by the planning board based on certain actions that have not yet taken place. The plan cannot be claimed to meet the 3 criteria. I think the review process that takes place before a decision is made on the land swap and the alternative compliance request is premature. If the board approves this plan, it can compel those who review the land swap and the alternative compliance petition to approve the request, since the DPZ recommended approval assuming the approval of those requests. This creates a bias toward a certain outcome. I'm also concerned about the current quasi-judicial format of hearing cases. I think that the county has created a process that favors those who are steeped in the arcane rules and procedures of the review process. Just because a public hearing is held does not mean that a fair process has taken place. I'm concerned that legitimate environmental concerns and concerns over strains on public infrastructure will be overlooked because they were not presented in the procedurally appropriate fashion. I urge the board to not approve this plan, as it does not meet the requirements set forth by the 3 criteria.
Thank you.